Nature of law and the law of contract. The nature of law and the law of contract explores the nature of law within a broader social context, examining how law relates to morality, justice, and society, as well as considering its evolving character. It draws together knowledge of the English legal system, legal rules and principles, and key concepts and debates from across the course. The exam also centers on the fundamental principles of contract law, from the formation of agreements to their enforcement. Introduction to the nature of law. The nature of law is a system of rules and principles created and enforced by the state to regulate behavior and maintain social order. Law and rules. The law is a formal mechanism of social control that sets standards of conduct and provides consequences for those who breach them. Whereas rules are guidelines or expectations that govern behavior in society, they are not always legally binding or enforced by the state. The difference between legal rules and principles and other rules and norms of behavior are that legal rules are enforceable by courts and sanctions, where other norms rely on social approval or moral pressure. Law, morality, and justice. There are many connections between law, morality, and justice. The connection between law and morality is that law is often influenced by moral values, although it does not always reflect what society considers morally right. The connection between law and justice is that the law aims to achieve justice by providing fairness, consistency, and protection of rights, although it may sometimes fall short. The connection between morality and justice is that moral principles shape ideas of what is fair and right, where justice seeks to apply those principles equally within society. Civil and criminal law. Civil and criminal law is the two main branches of law, where civil law deals with disputes between individuals and criminal law deals with offenses against the state. Civil law. Civil law is the area of law that resolves disputes between individuals or organizations, usually over rights, obligations, or compensation. The procedures in civil law are based on one party bringing a claim against another, using standards such as the balance of probabilities. The purposes of civil law are to resolve disputes, enforce rights, and provide remedies where harm has occurred. The outcomes of civil law are remedies such as damages, injunctions, or specific performance rather than punishment. The court systems of civil law are mainly the county court, the high court, and appellate court such as the Court of Appeal and Supreme Court. Criminal law. Criminal law is the area of law that deals with conduct considered harmful to society and prosecuted by the state. The procedures in criminal law are based on the prosecution proving the defendant's guilt beyond reasonable doubt. The purposes of criminal law are to punish wrongdoing, deter crime, protect the public, and maintain social order. The outcomes of criminal law are sanctions such as imprisonment, fines, community orders, or acquittal. The court systems of criminal law are the Magistrates' Court, the Crown Court, and appellate court such as the Court of Appeal and Supreme Court. Differences between civil and criminal law. The differences between civil and criminal law are that civil law focuses on private disputes and compensation, where criminal law focuses on public wrongdoing and punishment. The differences between the procedures in civil and criminal law are that civil cases are brought by individuals using the balance of probabilities, where criminal cases are brought by the state using beyond reasonable doubt. The differences between the purposes of civil and criminal law are that civil law aims to resolve disputes and compensate loss, where criminal law aims to punish and deter offending. The differences between the outcomes of civil and criminal law are that civil law results in remedies, where criminal law results in penalties or acquittal. The differences between the court systems of civil and criminal law are that civil cases are heard mainly in the county court and high court, where criminal cases are heard in the Magistrates' Court and Crown Court. The development of English law. English law has been developed through custom law, common law, and statute law. Custom law. Custom law is law that arises from long-established practices that are accepted as legally binding by society. Custom law has been developed through repeated behavior over time that is regarded as reasonable, certain, and continuous. In the early stage of development, custom law emerged from local practices that communities consistently followed as obligatory rules of behavior. In the later stage of development, customs were recognized by courts once they were proven to be long-standing, reasonable, and accepted by the community. Custom law is applied by the courts where they recognize a custom as legally binding and enforce it as part of the law. This is shown in the case of New Haven Port and Properties Limited v East Sussex County Council. Common law. Common law is law created by judges through decisions made in court cases rather than by Parliament. Common law has been developed through judicial precedent, where decisions in earlier cases guide the outcomes of later similar cases. In the first stage of development, judges decide cases based on reasoning and fairness where no statute applies. In the second stage of development, those decisions are recorded and become binding or persuasive precedents for future cases. Common law is applied by judges who follow the doctrine of precedent when deciding cases. This is shown in the case of Robinson v Chief Constable of West Yorkshire Police. Statute law. Statute law is law created by Parliament through Acts of Parliament. Statute law has been developed through the legislative process, where proposed laws are debated and approved by Parliament. In the first stage of development, a bill is introduced and examined in both Houses of Parliament. In the second stage of development, the bill receives royal assent and becomes an Act of Parliament. Statute law is applied by the courts, which interpret and enforce legislation passed by Parliament. This is shown in the case of Miller v Prime Minister. The rule of law. The rule of law is the principle that everyone, including the state, is subject to and accountable under the law. Importance of the rule of law. The rule of law is important for achieving justice as it ensures fairness and consistency in how laws are applied and enforced. However, it may not be important as strict application of the law can sometimes lead to outcomes that seem unfair in individual cases. The rule of law is important for human rights as it limits arbitrary use of power and protects individuals from abuse by the state. However, it may not be important as governments can still restrict rights through laws that are formally valid but morally questionable. The rule of law is a guiding principle of law as it underpins legal certainty, accountability, and equality before the law. However, it may not be as effective where those in power are able to influence or bypass legal processes. Elements of the rule of law. The core elements of the rule of law are equality before the law, legal certainty, and access to justice. Equality before the law means that all individuals and authorities are subject to the same laws regardless of status or power. Equality before the law is a guiding principle of law as it prevents arbitrary discrimination and ensures fairness in legal decision-making. Legal certainty means that laws are clear, publicized, and applied consistently so people can understand their legal rights and duties. Legal certainty is a guiding principle of law as it allows individuals to plan their actions and trust the legal system. Access to justice means that individuals are able to enforce their rights through fair and impartial courts. Access to justice is a guiding principle of law as it ensures that legal rights are meaningful rather than theoretical. Evaluation of the rule of law. The benefits of the rule of law are protection from arbitrary power, fairness and equality, and legal certainty. Protection from arbitrary power is a benefit as it restricts government action, shown in Miller v Prime Minister. Fairness and equality are benefits as the law applies equally to all, shown in R v Judge. Legal certainty is a benefit as it provides clarity and predictability, shown in Unison v Lord Chancellor. However, the drawbacks of the rule of law are rigidity, potential injustice in individual cases, and limited protection against unjust laws. Rigidity is a drawback as strict adherence to rules can ignore individual circumstances, shown in R v Be. Potential injustice in individual cases is a drawback as equal treatment can still produce unfair outcomes, shown in R v Hallam. Limited protection against unjust laws is a drawback as laws can be valid yet unfair, shown in R v Secretary of State for the Home Department. Law and morality. Laws are formal rules created and enforced by the state to regulate behavior and maintain order within society. Whereas morality is a set of personal and societal beliefs about right and wrong that guide individual behavior without formal enforcement. Laws and morals. The functions of law are to maintain social order, protect rights, resolve disputes, and provide predictable standards of behavior. The functions of morals are to guide individual conscience, shape social values, and influence behavior through social approval or disapproval. Law and morality overlap as many laws reflect moral values held by society, such as prohibitions on harming others. There is an overlap between immoral and illegal acts, as certain behaviors, such as theft or murder, are both morally wrong and prohibited by law. However, the difference between immoral and illegal acts is that some actions may be considered morally wrong without being legally prohibited, or illegal without being widely viewed as immoral. Legal theories. There are two main legal theories that underpin the law, which are legal positivism and natural law. The theory of legal positivism is that law derives its authority from formal sources such as Parliament, rather than from moral content. The theory of natural law is that law is based on inherent moral principles and that unjust laws lack true legal authority. Pluralism. A pluralist society is one where a range of different cultures, religions, values, and beliefs coexist within the same community. Pluralism is a key factor in shaping morality in society, as different groups bring their own moral values, influencing what is considered right and wrong. For example, moral views on issues such as same-sex relationships or euthanasia can vary significantly between cultural or religious groups. Moral views are diverse in a pluralist society as individuals are influenced by different traditions, experiences, and belief systems. For example, attitudes towards abortion or drug use may differ widely depending on personal, cultural, or religious perspectives. The relationship between law and morals. The relationship between law and morals is that law is often influenced by moral values, but it does not always reflect the full range of moral beliefs held in society. This relationship is important as it helps ensure that laws are seen as legitimate and acceptable by the public. However, this may not be important as the law must remain clear, consistent, and enforceable even where moral views differ widely. An example of where morality and law have clashed in courts is Lee v. Asher's Baking Company Limited 1918, where religious beliefs conflicted with equality law over discrimination. Another example is DPP v. Ziegler 2021, where moral views on protest clashed with legal limits on public order and obstruction. Enforcement of morals. Moral values are enforced by law as the state translates widely accepted moral standards into legal rules that regulate behavior. This is done by Parliament passing legislation and courts applying and interpreting the law in specific cases. An example of moral values being enforced by law is DPP v. Ziegler 2021, where the Supreme Court balanced the moral importance of protest against the legal need to prevent obstruction of the highway. The Devlin-Hart debate. The Devlin-Hart debate is a legal debate about whether the law should enforce moral values or remain separate from morality. The main arguments in the Devlin-Hart debate are Devlin's view that law should enforce shared morality and Hart's view that law should protect individual freedom and less harm is caused to others. Devlin argues that society has the right to enforce common moral standards through law to preserve social cohesion, as shown in Lee v. Asher's Baking Company Limited 1918, where the court recognized the importance of protecting religious moral beliefs within the legal framework. Hart argues that the law should not enforce morality unless there is harm to others, as shown in DPP v. Ziegler 2021, where the court prioritized individual rights to protest over strict moral or public order objections. Evaluation of law and morality. The benefits of law and morality are that they promote social order, protect individual rights, and enhance the legitimacy of the legal system. Social order is a benefit as shared moral values reflected in law help regulate behavior and prevent harm, as shown in Patel v. Mirza 2016, where the Supreme Court relied on moral considerations to prevent enforcement of illegal contracts. Protection of individual rights is a benefit as moral principles guide the law to safeguard freedoms, as shown in DPP v. Ziegler 2021, where the court protected the moral importance of protest rights under the law. Legitimacy is a benefit as laws aligned with moral values are more likely to be respected and obeyed, as shown in Lee v. Asher's Baking Company Limited 2018, where the court balanced equality law with moral and religious beliefs. The drawbacks of law and morality are that they can conflict with pluralism, create legal uncertainty, and risk imposing majority morality on minorities. Conflict with pluralism is a drawback as enforcing a single moral view through law can marginalize minority beliefs, as shown in Lee v. Asher's Baking Company Limited 2018, where competing moral values led to social and legal tension. Legal uncertainty is a drawback as relying on moral judgment can make the law unpredictable, as shown in DPP v. Ziegler 2021, where differing views on morality and rights led to uncertainty over lawful protest. Imposing majority morality is a drawback as it can undermine individual autonomy and minority rights, as shown in Re Northern Ireland Human Rights Commission Abortion Case 2018, where strict moral views embedded in law conflicted with personal rights. Law and justice. Law is a system of rules created and enforced by the state that regulates behavior and resolves disputes within society. Whereas justice is the moral principle of fairness that aims to ensure people are treated equally and appropriately according to their actions and circumstances. Types of justice. The different types of justice within the law are distributive justice, procedural justice, and substantive justice. Distributive justice is concerned with the fair allocation of resources, rights, and punishments within society, as shown in R.V. Dudley and Stevens. Procedural justice focuses on fairness in the processes used to make legal decisions, as demonstrated in Intick v. Carrington. Substantive justice is about achieving fair and morally right outcomes through the law itself, as shown in R.V. Blau. Theories of justice. The theories of justice are natural law, legal positivism, and utilitarianism. Natural law theory argues that law should be based on moral principles that exist independently of human creation and are universal, meaning an unjust law is not a true law, as illustrated by the reasoning rejected in R.V. Dudley and Stevens. Legal positivism argues that law is valid if it is created by a recognized authority using accepted procedures, regardless of its moral content, meaning judges should apply the law as written, as demonstrated in R.V. Brown. Utilitarianism is based on the idea that laws should promote the greatest happiness for the greatest number of people, meaning individual rights may be limited to benefit society as a whole, as shown in R.V. Dudley and Stevens. Extent of justice. The law provides justice to a greater extent as it creates consistency and certainty through precedent, ensures fairness through established legal procedures, and protects individual rights against abuse of power. The law creates consistency and certainty through the doctrine of precedent, meaning similar cases are treated alike, which promotes fairness as shown in Donahue v. Stevenson. The law ensures fairness through established legal procedures such as the right to a fair trial, which promotes procedural justice as demonstrated in R.V. Ghosh. The law protects individual rights against abuse of power by limiting state authority, which ensures justice as shown in Intick v. Carrington. However, the law provides justice to a lesser extent as it can be rigid, may fail to consider moral fairness, and can be influenced by social and economic inequality. The law can be rigid because strict application of rules may lead to unjust outcomes, as shown in R.V. Blau where moral objections were not considered. The law may fail to consider moral fairness because judges are required to apply the law even if the outcome seems unjust, as demonstrated in R.V. Brown. The law can be influenced by social and economic inequality because access to justice often depends on financial resources, which can undermine fairness as illustrated in R.V. White. Evaluation of law and justice. The benefits of law and justice are the maintenance of social order, protection of individual rights, and promotion of fairness and equality. Law and justice maintain social order by setting clear standards of behavior and consequences for wrongdoing, which benefit society as shown in R.V. Church. Law and justice protect individual rights by holding others legally accountable for harm caused, as demonstrated in Donahue v. Stevenson. Law and justice promote fairness and equality by applying the same legal rules to everyone, which supports justice as shown in R.V. Smith. However, the drawbacks of law and justice are inflexibility, moral injustice in certain outcomes, and unequal access to legal remedies. Inflexibility is a drawback because strict legal rules can prevent judges from achieving fair outcomes in individual cases, as shown in R.V. Blau. Moral injustice is a drawback because the law may conflict with societal values, leading to outcomes that appear unfair, as demonstrated in R.V. Dudley and Stevens. Unequal access to legal remedies is a drawback because those with greater financial resources are often better able to pursue justice, which undermines equality as shown in R.V. White. Law and society. Law and society is the relationship between legal rules and social behavior, showing how law both reflects social values and influences how people act within a community. Role of law in society. The role that law has in society is to regulate behavior, resolve disputes, protect rights, and maintain social order by setting clear standards of acceptable conduct. Social control is the use of rules, norms, and sanctions to regulate individual and group behavior so that it conforms to societal expectations. Law can shape society through social control as it deters harmful behavior through punishment and encourages acceptable behavior through rewards and legal approval. Social control. The law is a social control mechanism, which means it formally controls behavior by enforcing rules backed by sanctions such as fines, imprisonment, or other legal consequences. The media can exaggerate or sensationalize certain behaviors, presenting them as a serious threat to society. This can lead to moral panic, where the public becomes fearful and demands action from lawmakers. As a result, new laws or harsher enforcement may be introduced to address the perceived problem, showing how media influences social change. Theories of social control. The theories behind law as a social control mechanism are functionalism, Marxism, and interactionism. Functionalism views law as a way to promote social stability and shared values by regulating behavior. Marxism sees law as a tool used by powerful groups to control and exploit less powerful groups. Interactionism focuses on how law labels individuals and how this labeling influences behavior. Law and society theories. The theories around law and society are consensus theory, conflict theory, and labeling theory. Consensus theory is the idea that laws are created based on shared values and agreement within society about what is right and wrong. It is reflected in the legal system as laws that protect widely accepted values such as prohibitions on murder and theft, which most members of society agree are wrong. Conflict theory is the view that law benefits powerful groups and is used to maintain their dominance over less powerful groups. It is reflected in the legal system as laws and enforcement practices that may disproportionately affect disadvantaged groups while protecting the interests of the wealthy or powerful. Labeling theory is the idea that individuals become deviant because they are labeled as such by society and authorities. It is reflected in the legal system as criminal records and court processes that can reinforce a deviant identity and increase the likelihood of reoffending. Realism. Realism is a theory that focuses on the practical causes of crime and how law should realistically respond to crime in society. The different viewpoints within realism are left realism and right realism. Left realism. Left realism is a theory that sees crime as caused by social inequality, deprivation, and relative disadvantage. Left realism has influenced laws and policies that focus on community policing and crime prevention. It has encouraged addressing social causes of crime such as poverty and lack of opportunity. This approach has also shaped victim-focused policies by recognizing the real harm crime causes to disadvantaged communities. Right realism. Right realism is a theory that views crime as a result of individual choice and lack of discipline. Right realism has led to tougher sentencing and greater emphasis on punishment as a deterrent. It supports policies such as zero-tolerance policing and longer prison sentences. This has influenced criminal law by prioritizing control and responsibility over rehabilitation. Evaluation of law and society. The benefits of law and society are the maintenance of social order, protection of individual rights, and promotion of fairness and equality. Maintaining social order is a benefit as law sets boundaries for behavior and consequences for wrongdoing, as shown in R.V. Church where unlawful conduct was clearly punished. Protecting individual rights is a benefit because the law holds others accountable for harm caused, as demonstrated in Donahue v. Stevenson where negligence law protected consumers. Promoting fairness and equality is a benefit as the law aims to treat individuals equally before the courts, as shown in R.V.R. where marital rape was recognized as a crime. However, the drawbacks of law and society are inequality in enforcement, discrimination, and overcriminalization. Inequality in enforcement is a drawback as laws may be applied more harshly to certain groups, as seen in R.V. Grant where stop and search powers raised concerns about unfair targeting. Discrimination is a drawback because the legal system can reflect societal biases, as highlighted in R.V. Birmingham City Council where unequal treatment was challenged. Overcriminalization is a drawback as too many behaviors are controlled by law, limiting individual freedom, as shown in R.V. Brown where consensual acts were criminalized. Rules and theory of contract law. Contract law is the area of law that governs legally binding agreements between parties and sets out how contracts are formed, enforced, and remedied when breached. Rules of contract law. The rules of the law of contract are the parties to the contract, the burden of proof, sources of contract law, remedies, and consumer protection. The parties to the contract are the individuals or organizations who enter into a legally binding agreement, and they must have legal capacity and intention to be bound. This rule ensures that only valid parties can create enforceable contractual obligations. It also prevents contracts being enforced against those who lack capacity, such as minors in certain situations. The burden of proof is the responsibility placed on the claimant to prove that a valid contract exists and that it has been breached. This rule ensures fairness by requiring evidence before liability is imposed. It protects defendants from unproven or unjustified claims. Sources of contract law are the legal origins from which contract rules are derived, mainly case law and legislation. Case law develops principles through judicial decisions, while legislation provides statutory rules such as those protecting consumers. Together, they create a consistent and evolving framework for contract law. Remedies are the legal solutions available when a contract has been breached, such as damages or specific performance. Their purpose is to place the injured party in the position they would have been in had the contract been performed. This rule reinforces the binding nature of contractual obligations. Consumer protection refers to laws that safeguard consumers from unfair contract terms and practices. These rules recognize that consumers often have less bargaining power than businesses. As a result, the law intervenes to promote fairness and transparency. Theories of contract law. The theories around the law of contract are freedom of contract, acting on good faith, balancing interests and justice, the principle of fault, and inequality of bargaining power. Freedom of contract is the theory that parties should be free to negotiate and agree on their own contractual terms without interference. It reflects individual autonomy and market efficiency. However, it may be limited where agreements cause unfairness or harm. Acting on good faith is the idea that parties should behave honestly and fairly when forming and performing contracts. This theory promotes trust and cooperation between contracting parties. It challenges purely self-interested behavior in contractual relationships. Balancing interests and justice is the theory that contract law should fairly balance the rights of both parties. It aims to ensure outcomes are morally just rather than strictly legalistic. This theory supports judicial intervention where strict rules cause unfair results. The principle of fault is the idea that liability for breach of contract should be based on blameworthy behavior. It suggests that responsibility should arise where a party has failed to meet agreed obligations. This theory links contract law to concepts of accountability and responsibility. Inequality of bargaining power is the theory that parties do not always negotiate contracts on equal terms. It recognizes that stronger parties may exploit weaker ones, such as consumers or employees. This theory justifies legal protection and regulation to reduce unfairness. Formation of a contract. The formation of a contract is the process by which a legally binding agreement is created between parties through recognized legal elements. To form a contract, there must be an offer, acceptance, intention to create legal relations, and consideration. Offer and acceptance. An offer is a clear and definite promise to be bound on specific terms once accepted, as shown in Carlisle v. Carbolic Smoke Ball Company. Acceptance is the unconditional agreement to all the terms of an offer, as shown in Brogden v. Metropolitan Railway Company. An invitation to treat is an indication that a party is willing to negotiate rather than be legally bound, as shown in Fisher v. Bell. A bilateral offer is a promise exchanged for a promise, whereas a unilateral offer is a promise exchanged for an act, as shown in Carlisle v. Carbolic Smoke Ball Company. A counteroffer is a response that changes the original terms and therefore rejects the original offer, as shown in Hyde v. Wrench. The rule of communication is that acceptance must be communicated to the offerer to be effective, as shown in Tours v. Miles Far East Corporation. The rule of revocation is that an offer can be withdrawn at any time before acceptance provided the withdrawal is communicated, as shown in Byrne v. Van Tyenen. Intention to create legal relations. Intention to create legal relations means that the parties intend their agreement to be legally binding, as shown in Balfour v. Balfour. Domestic contracts. A domestic contract is an agreement made between family members or friends in a social or household context. The presumption for domestic contracts in regard to the intent to create legal relations is that the parties do not intend to be legally bound, as shown in Balfour v. Balfour. This can be rebutted when the parties are separated or dealing at arm's length, as shown in Merritt v. Merritt. Commercial contracts. A commercial contract is an agreement made in a business or trade context between parties. The presumption for commercial contracts in regard to the intent to create legal relations is that the parties do intend to be legally bound, as shown in Edwards v. Skyways. This can be rebutted when the parties expressly state that the agreement is not legally binding, as shown in Rose and Frank v. Crompton. Consideration. Consideration in a contract is something of value given in exchange for a promise, as shown in Curry v. Meiser. The rules of consideration are adequacy, sufficiency, past consideration, and pre-existing duties. Adequacy means that consideration does not need to be of equal value as long as something of value is provided, as shown in Chappell v. Nessel. Sufficiency means that consideration must have some value in the eyes of the law but does not need to be economically adequate, as shown in Thomas v. Thomas. Past consideration means that something done before a promise is made cannot amount to valid consideration, as shown in Ream Cardle. Pre-existing duties means that performing an existing contractual duty is generally not valid consideration for a new promise, as shown in Stilk v. Myrick. Privity of contract. Privity of contract is the principle that only parties to a contract can enforce its terms, as shown in Tweddle v. Atkinson. The rule of privity is that a third party cannot sue or be sued on a contract to which they are not a party, as shown in Dunlop Pneumatic Tyre Co. Limited v. Selfridge. Common law exceptions. Common law exceptions to privity develop to reduce the unfairness of the strict privity rule by allowing third parties limited rights in specific situations. These include collateral contracts, where a separate contract exists alongside the main contract as shown in Shanklin Pier Limited v. Detel Products Limited, an agency, where an agent can create rights and obligations for a principal as shown in Dunlop v. Selfridge. Other exceptions include trusts, where a contract is made for the benefit of a third party as shown in Les Affriches Runis v. Leopold Walford, an assignment, where contractual rights are transferred to a third party. Statutory exceptions. Statutory exceptions to privity are mainly found in the Contract Rights of Third Parties Act 1999, which significantly reformed the common law position. The Act allows a third party to enforce a term of a contract where the contract expressly states this or where the term purports to confer a benefit on them, provided they are identified by name, class, or description, as shown in Nishin Shipping Co. Limited v. Cleaves & Co. Limited. However, the parties to the contract can exclude the Act entirely if they clearly state that third-party rights do not apply. Terms of a contract. The terms of a contract are the specific promises, obligations, and rights that the parties agree will be legally binding. The concept of terms is the classification of contractual promises to determine their content, importance, and legal effect. The concept of incorporation is the process by which contractual terms become part of a legally binding agreement. Express and implied terms. Express terms are terms that are clearly stated orally or in writing at the time the contract is formed, as shown in Bannerman v. White. Whereas implied terms are terms that are not expressly stated but are inserted into the contract by the courts or statute, as shown in the Moorcock. Express terms. Express terms through common law are clear statements made during negotiations that the courts recognize as contractual binding, as shown in Bannerman v. White. Express terms by statute law are written contractual terms that must comply with statutory controls on fairness and transparency, as shown in Director General of Fair Trading v. First National Bank. Implied terms. Implied terms through common law are terms implied by the courts to give business efficacy or reflect obvious intentions, as shown in the Moorcock. Implied terms by statute law are terms automatically included by legislation to protect parties, as shown in Stevenson v. Rogers. Implied terms by course of dealings are terms implied due to consistent previous transactions between the parties, as shown in Spelling v. Bradshaw. Implied terms by the Consumer Rights Act 2015 are statutory protections ensuring goods and services are of satisfactory quality and fit for purpose, as shown in Rogers v. Parish. Types of terms. The different types of terms are conditions, warranties, and innominate terms. A condition is a vital term that goes to the root of the contract, as shown in Poussard v. Spires and Pond. A term will be identified as a condition where it is fundamental to the contract and goes to the root of the agreement, meaning a breach allows the innocent party to terminate the contract and claim damages, which is shown in Poussard v. Spires. A warranty is a minor term where a breach does not allow termination of the contract, as shown in Bettini v. Jai. An innominate term is a term that cannot be classified as either a condition or a warranty until it is breached, as shown in Hong Kong Fur Shipping Co. Ltd v. Kawasaki Kisen Kaisha Ltd. Different approaches. The term-based approach is the method where the court classifies the term in advance to determine the remedy for breach, as shown in Poussard v. Spires and Pond. The benefits of this approach are certainty, predictability of outcomes, and ease of application. Whereas the problems of this approach are rigidity, potential unfairness, and failure to reflect the seriousness of the breach. The breach-based approach is the method where the court looks at the consequences of the breach rather than the label of the term, as shown in Hong Kong Fur Shipping Co. Ltd v. Kawasaki Kisen Kaisha Ltd. The benefits of this approach are flexibility, fairness, and a focus on the actual impact of the breach. Whereas the problems of this approach are uncertainty, reduced commercial predictability, and increased judicial discretion. Breach of terms. There are different consequences for breach of each type of term. The consequences for a breach of a condition are that the innocent party may terminate the contract and claim damages, as shown in Poussard v. Spires and Pond. The consequences for a breach of a warranty are that the innocent party may only claim damages, as shown in Bettini v. Jai. The consequences for a breach of an innominate term are that termination depends on whether the breach deprives the innocent party of substantially the whole benefit of the contract, as shown in Hong Kong Fur Shipping Co. Ltd v. Kawasaki Kisen Kaisha Ltd. Types of clauses. There are two types of clauses that a contract can have: exclusion clauses and limitation clauses. Exclusion clauses. An exclusion clause is a term that attempts to completely remove liability for breach of contract or negligence. The common law regulations of exclusion clauses are that the clause must be incorporated into the contract and clearly cover the breach, as shown in Thornton v. Shoe Lane Parking. The statutory regulations of exclusion clauses are found in the Consumer Rights Act 2015, which prevents unfair terms and bans exclusion of liability for death or personal injury caused by negligence. Exclusion clauses in non-consumer contracts are regulated by the Unfair Contract Terms Act 1977, as shown in Photo Production Limited v. Securica Transport Limited. Limitation clauses. A limitation clause is a term that restricts the amount of liability rather than excluding it completely. The common law regulations of limitation clauses are that the clause must be incorporated and brought to the attention of the other party, as shown in Interphoto Picture Library Limited v. Stiletto Visual Programs Limited. The statutory regulations of limitation clauses are contained in the Consumer Rights Act 2015, where terms must be fair and transparent. Limitation clauses in non-consumer contracts are regulated by the Unfair Contract Terms Act 1977, as shown in George Mitchell Limited v. Finney Lockseeds Limited. Vitiating factors. Vitiating factors are legal grounds where a contract that appears valid may be set aside because consent was not properly obtained. The different types of vitiating factors are misrepresentation and economic duress. Misrepresentation. Misrepresentation is a false statement of existing fact made by one party to another that causes the other to enter into the contract. This includes omissions, which in consumer contexts means failing to disclose information that would affect the consumer's decision, as shown in Spice Girls Limited v. Aprilia World Service BV. The Misrepresentation Act 1967 states that a person who has entered into a contract after a misrepresentation has been made to them may claim damages, and that the representer will be liable unless they can prove they had reasonable grounds to believe the statement was true. Types of misrepresentation. The different types of misrepresentation are fraudulent misrepresentation, negligent misstatement, statutory misrepresentation, and innocent misrepresentation. Fraudulent misrepresentation is a false statement made either knowingly without belief in its truth, or recklessly as to whether it is true or false, as shown in Derry v. Peake. The remedies for fraudulent misrepresentation are rescission and damages in the tort of deceit. Negligent misstatement is a false statement made carelessly where a special relationship gives rise to a duty of care, as shown in Headley Byrne v. Heller. The remedies for negligent misstatement are rescission and damages based on the loss caused by the negligence. Statutory misrepresentation is a false statement made by one party where they cannot prove they had reasonable grounds to believe it was true under Section 2 of the Misrepresentation Act 1967, as shown in Howard Marine v. Ogden. The remedies for statutory misrepresentation are rescission and damages assessed as if the misrepresentation were fraudulent unless the court exercises discretion otherwise. Innocent misrepresentation is a false statement made where the representer had reasonable grounds to believe it was true, as shown in Oscar Chess v. Williams. The remedies for innocent misrepresentation are rescission or damages in lieu of rescission at the discretion of the court under Section 2 of the Misrepresentation Act 1967. Economic duress. Economic duress is illegitimate economic pressure applied to force a party to enter into a contract without genuine consent, as shown in the Universe Sentinel. The nature of the threat must be illegitimate, meaning it involves unlawful pressure or lawful pressure used in bad faith, as shown in DSND Subsea Limited v. Petroleum Geo Services ASA. The consequences of the threat must leave the victim with no practical choice but to submit and enter the contract, as shown in the Atlantic Baron. The case of Powon v. Lau Yu Long sets out the extra criteria for economic duress, which are whether there was protest, whether there was an alternative course open, whether the victim was independently advised, and whether the victim took steps to avoid the contract. If there was protest, this means that the victim objected to the pressure at the time, indicating that their consent was not freely given. If there was no alternative course, this means that the victim had no realistic practical alternative but to agree to the demand. If the victim was independently advised, then they received legal or professional advice before entering the contract, suggesting they did so with voluntary and informed consent. If the victim took steps to avoid the contract, this means that their action to rescind supports the claim that the agreement was entered into under pressure. The remedies for economic duress are rescission, or cancellation, of the contract and restoration of the parties to their pre-contract positions. The limits of economic duress are that commercial pressure alone is insufficient, the threat must be illegitimate, and the victim must act promptly to avoid affirmation of the contract. Discharge of a contract. Discharge of a contract means the termination of the contractual obligations between the parties where they are released from further performance. A contract can be discharged through performance, frustration, or breach of contract. Discharge through performance. Discharge through performance means that both parties have fully and exactly carried out their contractual obligations. The exceptions to this are tender of performance, severable contracts, substantial performance, acceptance of partial performance, and delayed performance. Tender of performance means that one party has offered to perform their obligations but the other party refuses to accept that performance, as shown in Startup v. McDonald. Severable contracts mean that a contract is divided into separate parts where payment is due for each completed part, as shown in Honig v. Isaacs. Substantial performance means that a party has completed most of their contractual obligations and may claim the contract price, minus the cost of defects, as shown in Honig v. Isaacs. Acceptance of partial performance means that one party freely accepts incomplete performance, and they must pay a reasonable sum for the work done, as shown in Sumpter v. Hedges. Delayed performance means that performance is carried out later than agreed and may lead to a breach where time is of the essence, as shown in Bunge Corporation v. Tradax Export SA. Discharge by frustration. Discharge by frustration means that a contract is automatically terminated where an unforeseen event occurs with neither party at fault, making the performance of the contractual duties impossible, illegal, or radically different from what was agreed to. Grounds for frustration. The grounds for claiming frustration are impossibility, illegality, and a radical change in obligation. Impossibility means that the performance of the contractual duties become physically or legally impossible due to the destruction of the subject matter or the unavailability of an essential element, as shown in Taylor v. Caldwell. Illegality means that performance becomes unlawful after the contract has been formed due to a change in the law or circumstances, as shown in Metropolitan Water Board v. Dick Kerr & Co. Limited. A radical change in obligation means that the event transforms the nature of the contractual obligation so that they are fundamentally different from what was originally agreed, as shown in Davis Contractors Limited v. Fairham UDC. Limits to frustration. The limits to frustration are self-induced frustration, foreseeability, and mere hardship or increased expense. Self-induced frustration means that a party cannot rely on frustration where the frustrating event was caused by their own choice or fault, as shown in the Super Servant 2. Foreseeability means that frustration will not apply where the event was foreseeable and could have been provided for within the contract, as shown in the Eugenia. Mere hardship or increased expense means that frustration does not apply simply because performance has become more difficult or costly, as shown in Davis Contractors Limited v. Fairham UDC. Consequences of a frustrated contract. The consequences of a contract being frustrated are that it is automatically discharged when the frustrating event occurs, so the parties are released from further future obligations. Money paid before the frustrating event is recoverable and money due before the event no longer needs to be paid. This is subject to the court's discretion to allow a party to retain or recover expenses. A party who has provided a valuable benefit before the contract was frustrated may be entitled to receive a reasonable payment for that benefit, as shown in Fibrosa Spolker Axina v. Fairbairn Lawson Coombe Barber Limited. Breach of a contract. A breach of contract is a failure by one party to perform their contractual obligations without lawful excuse. The different types of breaches are actual breaches, repudiatory breaches, non-repudiatory breaches, and anticipatory breaches. Actual breach. An actual breach occurs at the time the performance of the contractual duty is due, as shown in the case of Bolton v. Mahadeva. The consequences of an actual breach are that the innocent party may claim damages and, if the breach is sufficiently serious, may also terminate the contract, as shown in Poussard v. Spires. Repudiatory breach. A repudiatory breach is a serious breach that goes to the root of the contract and allows the innocent party to terminate the contract and claim damages, as shown in the case of Hong Kong Fur Shipping Co. Limited v. Kawasaki Kisen Limited. The damages that can be awarded for a repudiatory breach are compensatory damages designed to place the innocent party in the position they would have been in had the contract been properly performed. A repudiatory breach of a condition occurs where a fundamental term of the contract is broken, giving the innocent party the right to terminate and claim damages. A repudiatory breach of an innominate term occurs where the effect of the breach deprives the innocent party of the benefit of the contract, allowing termination and damages. A repudiatory breach of a warranty would not usually arise because a warranty is a minor term, but if it were classified as repudiatory due to its consequences, it would allow termination and damages. Non-repudiatory breach. A non-repudiatory breach is a breach that does not go to the root of the contract and therefore only gives rise to a claim for damages, as shown in the cases of Bettini v. Jai and Bolton v. Mahadeva. The damages that can be awarded for a non-repudiatory breach are compensatory damages to cover the loss suffered, without the right to terminate the contract. A non-repudiatory breach of a condition would arise if the innocent party chose to continue the contract despite the breach, limiting their remedy to damages. A non-repudiatory breach of an innominate term occurs where the consequences of the breach do not deprive the innocent party of the whole benefit of the contract, so only damages are available. A non-repudiatory breach of a warranty occurs where a minor term is broken, and the innocent party is entitled only to claim damages. Anticipatory breach. An anticipatory breach is a breach that occurs before performance is due, and one party clearly indicates that they will not perform their contractual obligations, as shown in the case of Hoekstra v. de la Tour. The nature of an anticipatory breach is that it occurs through words or conduct, showing an intention not to be bound by the contract. The choices that the other party has are to accept the breach and terminate the contract immediately while claiming damages, or to continue the contract and wait until the time for performance. Remedies in contract law. An individual may receive remedies under contract law as a response to a breach of contract where the innocent party seeks to enforce their rights or obtain compensation. The types of remedies an individual could receive are damages, equitable remedies, and consumer remedies. Damages. Damages are a common law remedy designed to compensate the claimant for loss suffered as a result of a breach of contract. The basis for a claim in damages are that there must be a valid contract, a breach of that contract, and loss caused by the breach, as shown in the case of Robinson v. Harmon. Compensatory damages are intended to put the claimant in the position they would have been in had the contract been properly performed, as shown in the case of Robinson v. Harmon. Causation must be established as a direct link between the breach of contract and the loss suffered by the claimant. In contract law, causation is determined using the but-for test, as shown in the case of Barnett v. Chelsea and Kensington Hospital Management Committee. Remoteness of damage. Remoteness of damage means that only losses that are not too remote and arise naturally from the breach can be recovered, as shown in the case of Hadley v. Baxendale. This is required to receive damages as the loss must not be too remote and must have been within the reasonable foreseeability of the parties at the time the contract was made. Foreseeability of losses means that the type of loss must have been reasonably foreseeable to both parties when the contract was formed, as shown in the case of the Heron 2. This is required to receive damages, as only losses that were reasonably foreseeable when the contract was made are recoverable. Special situations. The special situations where an individual can receive damages include distress and loss of amenity. In cases of distress and inconvenience, an individual will receive damages where the contract was intended to provide pleasure or freedom from distress, as shown in the case of Jarvis v. Swan Tours. In cases of loss of amenity, an individual will receive damages where the purpose of the contract has been substantially deprived, as shown in the case of Ruxley Electronics and Construction Limited v. Forsyth. Mitigation and liquidation. The claimant must mitigate their loss, which means that they must take reasonable steps to reduce the loss that comes from the breach of contract, as shown in the case of British Westinghouse Electric and Manufacturing Co. Limited v. Underground Electric Railways Co. of London Limited. Liquidated damage clauses are a contractual term where the parties agree in advance a payable sum if a breach occurs, and they are enforceable if the amount protects a legitimate interest and is not out of proportion to the interest of the contract, as shown in the case of Cavendish Square Holding BV v. Macdessie. The enforceability of liquidated damage clauses depends on whether the clause represents a genuine risk of loss rather than a penalty, as shown in the case of Cavendish Square Holding BV v. Macdessie. Equitable remedies. Equitable remedies are discretionary remedies awarded by the courts where damages are inadequate to achieve justice. Specific performance is a court order requiring a party to carry out their contractual obligations, as shown in the case of Bezic v. Bezic. Injunctions are court orders requiring a party either to refrain from doing a specific act or to carry out a particular act, as shown in the case of Lumley v. Wagner. However, these equitable remedies may not be granted if the claimant has not acted equally, if there has been delay, or if supervision by the court would be impractical. Consumer remedies. Consumer remedies are statutory rights available to consumers where goods, services, or digital content fail to meet the required legal standards. They are governed by the Consumer Rights Act 2015, which sets out the standards that goods and services must meet and the remedies available where those standards are breached. The right to reject, or partially reject a good, means that a consumer can refuse goods that are not of satisfactory quality, fit for purpose, or as described and obtain a refund, as shown in the case of Rogers v. Parish Limited. There is a time limit, which is 30 days from delivery. This is because the short-term right to reject must be exercised within a clear statutory period to ensure certainty for both parties. This right must be exercised by clearly informing the trader of the decision to reject and making the goods available for return or collection. This is shown in the case of Clegg v. Anderson. Reduction in price is a remedy where the consumer may keep the goods and claim an appropriate reduction where repair or replacement is impossible or unsuccessful, as shown in the case of Bernstein v. Pampson Motors Limited. Having work redone is a remedy where a consumer can require the trader to repeat a service to the required standard at no extra cost and within a reasonable time, as shown in the case of Honig v. Isaacs. Evaluation of contract law. The benefits of contract law are that it promotes certainty, protects reasonable expectations, and supports commercial reliability, whereas the drawbacks are that it can be rigid, complex, and sometimes produce unfair outcomes. Formation of a contract. The formation of a contract is the legal process where a binding agreement is created between parties and includes offer and acceptance, intention to create legal relations, and consideration. Offer and acceptance. Offer and acceptance is the process where one party makes a clear and definite offer that is accepted unconditionally by another party, creating agreement. The benefits of the law on offer and acceptance are that it provides certainty, uses clear objective tests, and distinguishes clearly between offers and invitations to treat. The benefit that it provides certainty is that clear rules about communication and acceptance allow parties to know when they are legally bound, as shown in Intours Limited v. Miles Far East Corporation. The benefit that it uses an objective approach is that agreements are judged by outward conduct rather than hidden intention, promoting fairness and predictability, as shown in Smith v. Hughes. The benefit that it distinguishes offers from invitations to treat is that it protects sellers from being bound too easily in retail situations, as shown in Pharmaceutical Society of Great Britain v. Boots Cash Chemists. The drawbacks of the law on offer and acceptance are that some rules are outdated, communication rules can be artificial, and distinctions can be overly technical. The drawback that some rules are outdated is that the postal rule can create unfairness by binding an offer before acceptance is received, as shown in Adams v. Linsell. The drawback that communication rules can be artificial is that silence cannot amount to acceptance even where it may reflect genuine agreement, as shown in Feldhaus v. Binderley. The drawback that distinctions can be overly technical is that complex analysis of counter-offers can defeat genuine agreement, as shown in Hyde v. Wrench. The possible reforms for offer and acceptance are to abolish the postal rule, codify the rules in statute, and introduce greater flexibility for electronic communications. The reform of abolishing the postal rule would increase fairness and align the law with modern communication methods, but it may reduce certainty for offerees who rely on posting acceptance. The reform of codifying the rules in statute would improve accessibility and clarity, but it may reduce judicial flexibility and the ability to adapt to new situations. The reform of introducing clearer rules for electronic communication would modernize the law and reflect commercial practice, but it may create complexity where different technologies require different treatment. Intention to create legal relations. Intention to create legal relations is the requirement that parties must intend their agreement to be legally binding before a contract is formed. The benefits of the law on intention to create legal relations are that it prevents trivial claims, reflects social reality, and promotes commercial certainty. The benefit that it prevents trivial claims is that domestic arrangements are presumed not to be legally binding, reducing unnecessary litigation, as shown in Balfour v. Balfour. The benefit that it reflects social reality is that social agreements are treated differently from business agreements, preserving personal relationships, as shown in Jones v. Padavatten. The benefit that it promotes commercial certainty is that business agreements are presumed to be binding, supporting trade and economic stability, as shown in Edwards v. Skyways Limited. The drawbacks of the law on intention to create legal relations are that presumptions can be artificial, outcomes can be unpredictable, and some deserving parties may be denied remedies. The drawback that presumptions can be artificial is that domestic agreements may be legally binding where relationships have broken down, creating inconsistency, as shown in Merritt v. Merritt. The drawback that outcomes can be unpredictable is that determining intention can depend heavily on specific facts, leading to uncertainty, as shown in Simpkins v. Pays. The drawback that deserving parties may be denied remedies is that reliance on informal promises may not be protected where intention is not proven, as shown in Balfour v. Balfour. The possible reforms for intention to create legal relations are to abolish presumptions, codify the doctrine, and replace it with a reliance-based test. The reform of abolishing presumptions would allow courts to focus entirely on the facts of each case, but it may reduce certainty and increase litigation. The reform of codifying the doctrine would improve clarity and accessibility, but it risks oversimplifying a nuanced area of law. The reform of replacing the doctrine with a reliance-based test would protect parties who act on promises, but it may undermine freedom of contract and expand liability excessively. Consideration. Consideration is the requirement that each party must provide something of value in exchange for a promise for a contract to be enforceable. The benefits of the law on consideration are that it distinguishes enforceable agreements from gifts, supports reciprocity, and promotes certainty. The benefit that it distinguishes enforceable agreements from gifts is that only bargains are legally binding, preventing excessive claims, as shown in Curry v. Meiser. The benefit that it supports reciprocity is that both parties must provide value, ensuring fairness in exchange, as shown in Dunlop Pneumatic Tyre Co. Limited v. Selfridge. The benefit that it promotes certainty is that the rule against past consideration clarifies when obligations arise, as shown in Ream Cardle. The drawbacks of the law on consideration are that it can be technical, inflexible, and sometimes unjust in commercial practice. The drawback that it is technical is that performing an existing duty may not amount to good consideration, producing artificial distinctions, as shown in Stilk v. Myrick. The drawback that it is inflexible is that part payment of a debt is not good consideration for the whole, even where agreed, as shown in Folks v. Beer. The drawback that it can be unjust in commercial practice is that practical benefits are sometimes recognized inconsistently, creating uncertainty, as shown in Williams v. Roffey Brothers and Nichols Limited. The possible reforms for consideration are to abolish the doctrine, to expand the doctrine of promissory estoppel, and to recognize practical benefit more consistently. The reform of abolishing the doctrine would simplify contract formation and align English law with other jurisdictions, but it may remove an important filter distinguishing serious agreements from casual promises. The reform of expanding promissory estoppel would promote fairness and protect reliance, but it may undermine certainty and blur the boundaries of enforceability. The reform of recognizing practical benefit more consistently would reflect commercial reality and reduce technical disputes, but it may weaken the requirement for genuine exchange and increase opportunistic claims. Terms of a contract. The terms of a contract are the specific promises and obligations that form the content of the agreement and include express terms and implied terms. Privity of contract. Privity of contract is the rule that only parties to a contract can sue or be sued on it. The benefits of the law on privity of contract are that it protects party autonomy, prevents excessive litigation, and promotes certainty. The benefit that it protects party autonomy is that only those who agreed to the contract are bound by it, preserving freedom of contract, as shown in Dunlop Pneumatic Tyre Co. Limited v. Selfridge. The benefit that it prevents excessive litigation is that third parties cannot interfere in private agreements, reducing unnecessary claims, as shown in Tweddle v. Atkinson. The benefit that it promotes certainty is that contractual liability is clearly limited to identifiable parties, supporting commercial predictability, as shown in Bezic v. Bezic. The drawbacks of the law on privity of contract are that it can cause injustice to third parties, undermine commercial intentions, and require artificial legal devices to avoid unfairness. The drawback that it can cause injustice is that a third party who was intended to benefit may be unable to enforce the contract, as shown in Tweddle v. Atkinson. The drawback that it can undermine commercial intentions is that parties may clearly intend to benefit a third party but the law may not give effect to that intention, as shown in Bezic v. Bezic. The drawback that it requires artificial devices is that courts have relied on trusts or agency to avoid harsh outcomes, complicating the law, as shown in Jackson v. Horizon Holidays Limited. The possible reforms for privity of contract are to expand statutory rights for third parties, abolish the doctrine entirely, and clarify the scope of third-party enforcement. The reform of expanding statutory rights for third parties would improve fairness and reflect commercial practice, but it may increase litigation and reduce certainty for contracting parties. The reform of abolishing the doctrine entirely would align the law with modern expectations and simplify enforcement, but it could undermine party autonomy and expose parties to unexpected liability. The reform of clarifying the scope of third-party enforcement would improve certainty and accessibility, but it may limit judicial flexibility in achieving just outcomes. Incorporation of terms. Incorporation of terms is the process by which contractual terms become binding through signature, reasonable notice, or previous course of dealing. The benefits of the law on incorporation of terms are that it promotes certainty, encourages clarity in drafting, and protects parties through notice requirements. The benefit that it promotes certainty is that a signed document will normally bind the parties regardless of whether it was read, as shown in Lestrange v. Graucob. The benefit that it encourages clarity in drafting is that terms must be clearly presented to be effective, incentivizing transparency, as shown in Thornton v. Shoe Lane Parking Limited. The benefit that it protects parties through notice requirements is that unusual or onerous terms must be brought to attention, promoting fairness, as shown in Interphoto Picture Library Limited v. Stiletto Visual Programs Limited. The drawbacks of the law on incorporation of terms are that it can be harsh, overly technical, and dependent on fine factual distinctions. The drawback that it can be harsh is that a person may be bound by unfair terms simply by signing a document, as shown in Lestrange v. Graucob. The drawback that it is overly technical is that small differences in timing can determine whether terms are incorporated, as shown in Ollie v. Marlborough Court Limited. The drawback that it depends on fine distinctions is that previous dealings must be regular and consistent, creating uncertainty, as shown in McCutcheon v. David McBrain Limited. The possible reforms for incorporation of terms are to strengthen statutory control, require clearer consent to onerous terms, and codify the rules. The reform of strengthening statutory control would enhance consumer protection, but it may increase costs for businesses and reduce freedom of contract. The reform of requiring clearer consent to onerous terms would promote genuine agreement, but it may create practical difficulties in fast-moving commercial contexts. The reform of codifying the rules would improve accessibility and consistency, but it may reduce flexibility in responding to new commercial practices. Classification of terms. Classification of terms is the process of categorizing contractual terms as conditions, warranties, or innominate terms to determine the appropriate remedy. The benefits of the law on classification of terms are that it provides structured remedies, allows flexibility, and promotes fairness. The benefit that it provides structured remedies is that breach of a condition allows termination and damages, creating clear consequences, as shown in Poussard v. Spires. The benefit that it allows flexibility is that innominate terms enable courts to assess the seriousness of breach, as shown in Hong Kong Fur Shipping Co. Limited v. Kawasaki Kisen-Kaisha Limited. The benefit that it promotes fairness is that minor breaches of warranties do not justify termination, preventing disproportionate outcomes, as shown in Bettini v. Jai. The drawbacks of the law on classification of terms are that it can create uncertainty, encourage litigation, and involve complex judicial interpretation. The drawback that it creates uncertainty is that it may be unclear whether a term is a condition or innominate term until litigation occurs, as shown in Hong Kong Fur Shipping Co. Limited v. Kawasaki Kisen-Kaisha Limited. The drawback that it encourages litigation is that parties may dispute the seriousness of breach to determine remedies, as shown in the Mihalis Angelos. The drawback that it involves complex interpretation is that courts must analyze the effects of breach in detail, increasing cost and delay, as shown in Sahave NVV Bremer Handelsgesellschaft MBH. The possible reforms for classification of terms are to adopt a unified seriousness of breach test, codify categories in statute, and expand the use of innominate terms. The reform of adopting a unified seriousness of breach test would increase flexibility and fairness, but it may reduce certainty at the time of contracting. The reform of codifying categories in statute would improve clarity and consistency, but it may create rigidity and limit judicial discretion. The reform of expanding the use of innominate terms would reflect commercial reality, but it may increase uncertainty and litigation over consequences. Exclusion clauses. Exclusion clauses are contractual terms that seek to limit or exclude liability for breach of contract or negligence. The benefits of the law on exclusion clauses are that it respects freedom of contract, enables risk allocation, and supports commercial certainty. The benefit that it respects freedom of contract is that parties can allocate risk as they see fit, particularly in commercial agreements, as shown in Photo Production Limited v. Securica Transport Limited. The benefit that it enables risk allocation is that businesses can control potential liability and price services accordingly, as shown in Elsa Craig Fishing Co. Limited v. Malvern Fishing Co. Limited. The benefit that it supports commercial certainty is that clearly drafted clauses will generally be upheld, providing predictability, as shown in Lestrange v. Graucob. The drawbacks of the law on exclusion clauses are that they can be unfair, rely on technical interpretation, and disadvantage weaker parties. The drawback that they can be unfair is that powerful parties may exclude liability for serious breaches, as shown in Photo Production Limited v. Securica Transport Limited. The drawback that they rely on technical interpretation is that courts may interpret clauses strictly against the party relying on them, creating unpredictability, as shown in Hollier v. Rambler Motors Limited. The drawback that they disadvantage weaker parties is that consumers may agree to broad exclusions without real bargaining power, as shown in Thornton v. Shoe Lane Parking Limited. The possible reforms for exclusion clauses are to strengthen statutory reasonableness tests, prohibit certain exclusions entirely, and require clearer drafting standards. The reform of strengthening statutory reasonableness tests would enhance fairness and consumer protection, but it may increase compliance costs and reduce commercial flexibility. The reform of prohibiting certain exclusions entirely would prevent serious injustice, but it may restrict legitimate risk management in commercial contracts. The reform of requiring clearer drafting standards would promote transparency and informed consent, but it may increase formality and complexity in contractual documentation. Rules and theory of contract law. Contract